So our fourth panel of today, and I really thank all of you for being here. I know it's been a long and intensive day of thinking and very, very, very rich talks, and I wanted to thank you for being here with us this evening. This panel is called Conscience Ethics, the Secular Conscience. And our first panelist is going to be Kent Greenawalt, and our second panelist actually could not make it here at the last moment. His flight was canceled coming out of New York. This is Jay Bernstein. So what I'll do is introduce Jay as if he was here. Nancy's going to read his paper after the first paper, and then she'll respond to both papers. So obviously, it will be a shorter Q&A, since it will be a little bit one-legged. But we thought it was important to have Jay's paper present, since he was very much looking forward to being here and really tried. He got on 3 consecutive flights, each of which were canceled. So it was a long 2 days for him. Yeah. Okay. So our first panelist, Kent Greenawalt, is university professor at Columbia Law School and former editor-in-chief of the Columbia Law Review. He's the author of numerous works, including Religion and the Constitution, which includes Volume 1, Free Exercise and Fairness, and Volume 2, Establishment and Fairness, as well as Does God Belong in Public Schools? And Private Consciences and Public Reasons. Our second absent panelist, Jay Bernstein, is University Distinguished Professor at the New School for Social Research. He's the author most recently of Against Voluptuous Bodies, Adorno's Late Modernism and the Meaning of Painting, Adorno, Disenchantment and Ethics, as well. He also co-authored Art and Aesthetics After Adorno, published through UC Berkeley's Townsend Center. And again, our respondent is Nancy Ruttenberg. We all know Nancy by now. All right, so without further ado, please welcome Kent Greenawalt.
It's a great pleasure to be here. I think this has been a very exciting and extremely interesting conference that Nancy's organized, and I think it's really a great occasion. I'm going to talk about claims of conscience and whether they should lead to exemptions from ordinary legal requirements. Now, the theory here is a lot more trivial in terms of the categories than most of the things we've been listening to, and the focus is on what practically should be done about these things in our society. I'm going to explore a number of different things, most of them fairly quickly, and the full paper is electronically available for those of you who would like to pursue these things in a little more detail. So I'll look at various senses of conscience, the need for a sense that's relevant and that's legally administrable when we're thinking about this thing about exemptions, when it's appropriate to grant concessions to conscience, and then the question, which we've touched on already a bit, is whether they should be limited to religious claims or extended to secular ones. Should they be given to individuals or organizations or both, and can organizations even have claims of conscience? I don't think that's a crucial question, but I'll say a little bit about that. Now, these issues can arise in a number of different kinds of ways. One is a question of legislative choices, what kind of statute should be adopted, or administrative regulations if things were left to the executive branch, constitutional claims, international human rights, as Marco Perry discussed. We can have discretion of executive officials. When I was Deputy Solicitor General for a year in terms of criminal cases, my early writing, one of my early pieces had been on electronic eavesdropping, and there was a case involving government wiretapping of organizations that were opposed to the Vietnam War, and I said to the Solicitor General, I would really rather not work on this case. I feel very strongly the government's position is wrong. And he said, okay. I finally had to do a little bit on a peripheral issue at the end because time was running out. But basically, he'd accommodated to what my moral claim was not to be working on that case. Then there are choices of private organizations, such as Stanford or Columbia, about whether if a student doesn't want to take an exam on Saturday because they think that's not something that they should be doing, whether to accommodate that. Now, I just want to say a very brief thing about the constitutional things and the statutory situation. My own sense is that beliefs and expressions of beliefs now, it doesn't matter under the First Amendment whether they're religious or not, because First Amendment free speech, I think, covers those for the non-religious claims. As far as the Supreme Court's concerned, it is okay to have statutory limits that are favorable to religion and single out religious organizations, and there are a number of statutes that do that, and most notably in the federal government, there's RFRA, Religious Freedom Restoration Act, and RLUIPA, which both do that. Now, legislative choices can involve both exemptions from government requirements, and there the sort of traditional one is pacifists and the draft. But government can also insist that private enterprises accommodate to claims of conscience, and most of the statutes that deal with abortion practice have such requirements that even private organizations cannot discriminate against people like nurses who would be refused to participate in abortions even if the hospital's doing them. Now, two prominent particular issues at our time involve same-sex marriage and provision of health care insurance that involves contraceptives, and I'll say a word about each of those. In my general account, in any general account, this one of mine, I'm going to focus on what counts as a relevant claim of conscience, and I'll ask whether exemption should be limited to religious claims. I'm going to say a bit about sincerity, which turns out to be far from a simple issue, and for practical purposes, it also matters how close someone's relation to the actions to which she objects is, and what considerations can outweigh claims of conscience, and whether laws should be cast in general terms or about specific problems like abortion. And I'm going to touch on most of these when I talk briefly about same-sex marriage and health insurance. So first of all, what's conscience and what are claims of conscience? And again, this is not getting into these deep questions that have been dealt with in most of the other discussions so far. But like many value-laden terms, conscience can be used in various ways. Now, I don't think that has to be a problem in ordinary discourse as long as someone understands the context in which the term is being used. So I think there are situations in which one might use conscience which wouldn't imply any intensity of conviction. So I might say, you know, my conscience really tells me I should be washing the dishes, but I really am going to watch the football game instead because that matters a lot to me. So that's not really a basic moral claim or involving a high degree of intensity, but the term might be used that way. And sometimes I think it's used to distinguish situations where one really can't think of good reasons or you don't want to give them. So you'd say, you know, this is wrong. I'm not really quite sure why it's wrong, but my conscience tells me it is. And I don't think that would necessarily imply any degree of intensity. Now, another important aspect of conscience is does it have a moral basis, and what about religious beliefs about actions that would conform with God's will, such as not working on Saturday, which doesn't seem to involve any sort of ordinary sense of morality. And I think it's clearly not enough for these purposes that we're talking about here that there's a strong sense of self-identification if that's not connected to some moral sense or a sense of religious obligation. So if a scholar said, you know, I'm not doing anything for my family, not spending any time with them, I realize I'm not much of a scholar anyway, but that's what my self-identity, so I'm going to continue to spend all my time reading and writing this mediocre stuff instead of taking care of my family. Well, that's not the kind of thing you would want to give an exemption for. And I thought of the example, having run in some marathons myself, I thought of Paul Ryan and imagined that, well, maybe for the next few years he'll feel he should really get into training and spend a lot of time so he could actually do the time that he said he did before. So that would be a question of self-identification. A relevant claim of conscience for these purposes would involve a strong intensity of conviction and a sense of serious moral wrong. I don't think, and this gets to something that Derek talked about, I don't think it has to be connected to a sense of the ultimate meaning of life. I think not everybody has a sense of the ultimate meaning of life, and I think even some people who do, and I think this includes some religious people, might have feelings of conscience about what they should do for their family or so on that they don't really connect in any way they've thought about carefully between their ultimate sense and what they feel they really have a strong responsibility to do. And I think for a genuine claim of conscience that would be relevant here, a person should believe that she should suffer a serious detriment rather than violate the conscience. Now, whether she'd actually be willing to do that is another question, but if she thought that, just any trivial thing would be enough to outweigh it, I don't think that would be the kind of thing we would think that would be a good basis for an exemption. Now, it's debatable whether organizations can have consciences. If one thought of a closely knit organization, which all people thought about the same thing, I think you might then say, this organization, as a matter of conscience, thinks such and such. But whatever, if leaders and members of the organization have claims of conscience that bear on what the organization should be required to do, we can imagine exemptions going to organizations. Now, this has been something that was discussed last time in the last discussion, and I think there's obviously some disagreement here about whether religious claims of conscience should be treated as special. Now, there are two basic reasons to accommodate conscience, I think. One is that we value liberty and autonomy. We don't want to require people to do what they believe is deeply wrong, and that could be true in private contexts like the family, if two spouses are thinking about doing something and one spouse says, well, we have to do such and such and you have to do this, and the other spouse says, no, but that would, I think that would be wrong, it would violate my conscience. That would be a very strong reason for the other spouse to say, okay, well, all right, then you don't need to do that and I'm not going to press you on that. Now, another reason to accommodate conscience are that you don't want to have sort of completely unproductive conflicts between what's demanded and what's actually taking place. So the draft is a good example of that. If somebody refuses to submit to the draft, you don't actually get a person to take the place of somebody else who's going to be drafted because they're going to jail instead. Then they're spending 2 years in jail not doing anything productive, and the government is spending money. And if they submit to the draft and then never fire their rifle when that's absolutely necessary for the protection of their fellow soldiers, that's hardly better. And then there's this practical sense that all people can benefit from the development of moral senses among other individuals in a diverse society. Now, I think that at least for the purposes of what I'm talking about, there's no doubt that non-religious conscience does exist. That is, a conscientious feeling that's not based on some kind of religious premise or claim. And there's the plurality in a case called Welch versus United States sort of pushes in the other direction, reading the Selective Service Act. It says those whose conscience spurred by deeply held moral, ethical, or religious beliefs would give them no rest or peace. They qualified as based on religious belief under the Act, and I think that's an extension and really one that can't be justified in any ordinary sense of what these terms mean. Now, there are two reasons not to single out religion, at least. One is it's intrinsically unfair, as, again, going back to the draft situation. And secondly, there is then a line drawing problem as to what counts as religion and what doesn't count as religious, and that can be very difficult in some borderline cases. Now, on the other hand, as earlier discussion today indicates, there is a constitutional protection for religion that seems to be special. And I think this is important, and this might be something we want to discuss. I think that with some frequency, there is an absence of comparable non-religious views. Now, that's not true about the draft, but if somebody believes as a matter of conscience that they should never eat pork, as opposed to being a vegetarian, but never eat pork or never use a contraceptive device, it seems to me that it's not impossible, but very hard to think of non-religious views that would lead to claims of conscience of this sort. So that would be a reason why it might be okay to single out the religious claim. Then there's a more subtle question about what message the government's sending about a moral stance. Now, I think the government is better able to make factual judgments, and it's better able to make rational assessments of value and judgments based on shared cultural sense than it is competent, and it's really incompetent, and I think the discussion between Michael and Derek this morning indicated that. It really is incompetent to make judgments about religion. Now, it's a bit tricky when you get to something like a just war thing where it's a religious underpinning, but there's based on factual claims. But anyway, basically, the government is less well-suited, I think, to evaluate religious claims. And then there's a question of what message the government is sending. So the government may not want to concede that the basic position taken by the claimants is a plausible position. So if we think about gender discrimination, for instance, if we limit an organizational exemption to religious groups, and especially, let's say, in terms of selecting clerics, that doesn't seem to send a message that gender discrimination is really okay in general. But if you said all organizations that have strong convictions that their officers should be members of one gender or another can, classify on that ground, I think that would send a different message. And one might think that would be much more troubling. And then finally, there's, I think, a fairly subtle problem about a possible kind of conscientious claim, which I think is more likely to come up with a non-religious moral outlook, although one can imagine it with a religious one. And I'll use vaccination as the example here. Suppose the parents think basically their main responsibility is to protect their own children, and almost everybody's been vaccinated against a particular disease, and the parents think, well, the risk of my kid having the vaccination, that's actually going to be slightly higher than the risk that they might suffer if they don't get the vaccination but get the disease. So if I'm deciding on the basis of what's best for my kid, I'd say no, don't give them the vaccination. On the other hand, if he did happen to get the disease, that might well spread to other people. So the risk in general to children might be more if the child doesn't get the vaccination. So then we'd have a sort of a conscience focused on particular the family members that really is at odds with what the general interest would be for society overall. And I think that's a troublesome nuance. Now, my own belief is that usually for individuals, the line should not be drawn on the basis of religion. But I do think this is a contextual thing that depends on what the particular problem is. And I think for organizations, it would be much more common that if you're going to have them at all, it is more acceptable to limit them to religious organizations. And I'd be interested whether Michael disagrees with that. Certainly what he said this morning and this afternoon would seem to suggest he probably would disagree. Now, another problem is one about sincerity. So it can be difficult to assess. At the time of the Vietnam War, a lot of people didn't, and just to be clear, the draft exemption, you had to object to war in any form. It wasn't enough to object to a particular war. And a lot of people really did feel that they shouldn't be fighting in Vietnam. And then the question is, well, should they claim to be conscientious objectors, even if really they weren't in the sense that was used in the statute? So that's difficult to assess. The draft boards did that, were supposed to do that. At that point, when I was in the Solicitor General's office, by then the lower federal courts were basically requiring that the draft boards come up with objective evidence if they were going to deny exemptions, and that was very difficult for them to do. Now, the problem about sincerity doesn't apply if there's no actual ordinary advantage to getting the exemption. So for a druggist who says, you know, I really don't want to sell contraceptive pills, it's, you know, it might be that some of the people that are dealing with the druggist feel strongly about that, but basically it's hard to think of ordinarily some non-religious self-interested reason for wanting that particular exemption. On the other hand, if a parent says, you know, I really don't want to work, I can't work on Saturday, we could think, well, plenty of parents think they would rather be home with their family on Saturday, so there would be an incentive to claim an exemption that really wasn't based on conscience. Now, one might say, well, the standard should be what's the intensity of conviction and sense of magnitude. What would the person be willing to suffer would be one standard of how strongly they feel about this. But if the applicant's actually likely to succeed, then they're never going to be actually put to this test. And then there's a more subtle point that, about the degree of involvement. So thinking about somebody who registers patients coming into the hospital, and let's say they're strongly opposed to abortion, and they wish to make a statement by not registering the admittees to the hospital, and they say, I can't, as a matter of conscience, do this, to perform that part of the job. Now, maybe they're wanting to make this statement, but they don't, if they had to do this, they wouldn't feel as a matter of conscience, their conscience would be violated if they did it. So that's a kind of nuance of somebody who actually has a moral objection that we might think doesn't really amount to a claim of conscience not to do it. Now, I think one way of dealing with a sincerity problem, and one I favor, is to impose an alternative that most would take as being at least as bad or even worse than submission to the requirement itself. That's one way of testing whether somebody really doesn't want to, doesn't feel that they should be submitting. Then we get to the crucial problem of weighing how much damage is done to others if conscience is accommodated. So at one thing, you could have outright denial of benefits, inconvenience for people. Let's say if the only druggist in the community is not selling these things, if they have to go 30 miles to another druggist to get them, that's inconvenience. And then there's a question of insulting embarrassment. They get something that, but somebody says they're not going to serve them because they're doing this or so on, and others hear that, and it's very embarrassing. And they feel bad about being rejected in this kind of way. And then, of course, there's increased expense and inconvenience for those who provide the benefit, the owners of the drugstore and so on. And then there's the question, and this is a harder question, whether the basic message is regarded as unacceptable. And is that why the exemption is being given? To actually communicate something about the basic message. And I think the spread of the abortion exemptions did reflect a lot of legislators' views that the Supreme Court decision was actually wrong in that respect. And that might be true about same-sex marriage in some situations. I won't say much about this, but the formulation of exemptions can be specific or general, and we have both kinds of statutes, and I think both are appropriate. Now, turning to the particular conflicting claims, which I'm saying are, in this case, can be put as conflicting claims of toleration. First of all, same-sex marriage exemptions. Now, in contrast to not eating pork or being a pacifist, the opposition to same-sex marriage often conveys a negative attitude about homosexual relations. It doesn't have to. People can think homosexual relations are just as good as other sexual relations, but God conceives marriage differently as being between people of different genders. But it's widely perceived that opposition to same-sex marriage does involve a kind of prejudice and discrimination, and it's claimed with some frequency that there's a resemblance here to racial discrimination. And then there's a concern that giving the exemption will convey a message of intolerance toward the basic rights. So should there be any exemption, and if so, of what sort? Now, no religious institution has to perform marriages they believe are invalid. So the question is whether exemptions should go beyond that for organizations and individuals. Should religious organizations have to treat a couple as married for purposes of insurance? Should an individual government clerk have to marry a couple? Now, there are practical reasons right now, at this point in our history, to create exemptions, and I think it's been shown quite convincingly that in states that have passed these laws, in the majority of them, the creation of exemptions made it possible to get the legislation passed. But that reason may disappear if same-sex marriage continues to get more widely accepted, which I think, given the age differences in people that accept it, is extremely likely, at least in most parts or many parts of the country. Now, there has been drawn the comparison with racial discrimination. And most people are hesitant to respond to that, but I just want to say I think it's not a convincing comparison. First of all, racial discrimination has never treated races equally. What you needed to count as black in the southern communities, if you were 1/4 or 1/2 black, you certainly counted as black. So somebody who was 3/4 white could marry a black person, but couldn't marry a white person. So this is not equal treatment of races. This is protection of the white race as being superior. And I think, so that's one distinction. The other thing is that, in the history of the human race, marriage has almost universally been between people of different genders. And before modern technology, of course, this was how you were capable of having children. And so it seems to me there's a kind of history there that's quite different from anything that could be said positively about racial discrimination and racial segregation. I think there are two levels at which one can look at what I just said. One is what I've just said enough to think there actually is a rational distinction here? There's some basis to think that even if, I support same-sex marriage, but there would be some basis to think that marriage between people of different genders is somehow a bit more natural or something, and that it's sort of more understandable that people would think it should be limited in that way. But even if one rejects that completely and thinks it's completely irrational and really no more justified in terms of thinking about it than racial segregation or a bar on interracial marriage, nevertheless, in the society, given the history and so on, and even statutes that up until about a decade ago, although maybe not hardly ever enforced, that banned sexual relations between people of the same gender, that it's understandable that many people still have a hesitation about this and are opposed to it, and we know that many religious groups are still opposed to it. So I think that is a reason to think that this is different, and there is a strong reason to have some kind of exceptions. Here I think it's hard to think of non-religious reasons that have anything like the power of the religious ones. And I think for that reason, it makes sense to limit here the claims to religious claims. And I think for example, that religious organizations should be able to refuse peripheral involvement, such as rentals of hall for celebrations. I think probably they shouldn't be able to deny insurance company of couples that have gotten married lawfully according to civil standards, even if the church doesn't think that these are proper marriages. And I would draw a comparison there between people who are divorced and remarried, which, let's say, the Catholic Church wouldn't recognize the remarriage as being valid because they wouldn't recognize the divorce as valid, but still the insurance, I think, would cover those situations. As far as hiring is concerned, I think parochial schools can rightly not hire gay teachers or teachers who are members of same-sex marriage couple, but I don't think that should extend to those who happen to be working on the building in a physical way. In the exemptions that have been given so far in these statutes, they're mostly given to organizations, and I think that's unfortunate. I think that's probably a consequence of what was necessary to get the laws passed. I think the exemptions should extend to individuals, but only those who are closely involved in the marriage itself. So I do think that public officials, if there are other people available and it can be done without real embarrassment to the couple and so on, I think that a clerk should not have to perform a same-sex marriage. Now, the second conflicting claim of toleration, the insurance covering contraceptive devices. We know that the Obama concession was to allow religious organizations other than churches not to directly pay to cover insurance, but have the insurance company provide that. Now, I'm assuming it's okay for the government to dictate insurance requirements, and I'm also assuming that it should not impair the availability of contraceptives for women who can't comfortably afford them. Now, I think there are complexities about this, especially when one thinks of Roman Catholicism as being sort of the main opposition now to this. Most Roman Catholics use artificial contraceptives, and maybe some, I don't know what the percentages, think it's morally wrong, but they do it anyway, but I'm sure that many do not think it's morally wrong. And over the history of the church, and Nathan touched on this, there's a division over whether one who disagrees with church teaching, whether it's a sin to perform the act that the church condemns, or one should adhere to one's conscience. And Aquinas thinks that you should inform one's conscience largely on the basis of the understanding of the church, but he does suggest that it's a sin to violate your own conscience, and he recognizes that for some people that's not going to conform with what the church teaches. I'd say right now the church seems to be mostly in the other direction from that, but there is a division, and there has been historically. Is it relevant that the insurance company, the insurer, the company that's insuring the employees may actually save money if contraceptives are included in coverage? I think not. Yes, they might save money, but still they would feel bad or feel it's wrong if their money is going to support this, even if overall it's a saving of money. And there's a special problem which hasn't been discussed a lot, although people are clearly aware of it, and that is the morning after pills. And first of all, there's a factual question: do they preclude implantation of embryos or dislodging of fertilized eggs from the uterus? And I think there was a New York Times article suggesting that Plan B definitely, or almost definitely, doesn't do that, but for Ella it still seems fairly likely that that does happen occasionally. And of course this could seriously affect the sense of how wrong it would be to involve in this if the church view, or the religious view, is that this then becomes a taking of what already has become a human life. Now, many regard exemptions as reflecting a kind of insensitivity toward women, refusing to recognize their range of choice. Is this really like paying taxes? After all, organizations pay taxes, and some of those taxes may go and do go for things that they think are morally improper. And I actually think that this is pretty close if the insurance company itself is providing the coverage. But I think it's very important what the view of the organization is, and I think we have strong indications that many of the religious organizations do not take that view. I think there's a possible way out, and that might be to have the government itself pay for this and then charge a fee to the companies that are not providing this degree of coverage. So in summary, the question of what exemptions should be made as a matter of law or granted by those in charge of public and private enterprises depends partly on how one perceives the nature of conscience, its significance for individual liberty and social welfare. Now, the further questions are whether and how far religious claims of conscience are special, and whether any organization should be acknowledged as legitimately raising such claims. In relatively simple situations, an exemption for some may add to the burdens borne by others, but reflects no negative attitude about what the others are doing. Examples of these would be not requiring Orthodox Jews to work on Saturday and excusing pacifists from military service. In the more complex circumstances of same-sex marriage and health care insurance, the very granting of an exemption may reflect a strong negative attitude by those receiving it toward the activities for which they seek the exemption, and perhaps about the individuals who engage in them. Those who participate in the practices themselves may feel that an exemption somehow reinforces these negative attitudes and represents a form of intolerance or lack of concern for their identity and welfare. And I think we've seen that rhetoric, certainly, and probably belief in both these instances. As the discussions reflected, the problem seriously complicates decisions about what exemptions are a good idea, but I don't think it eliminates the desirability of some limited exemptions, and to show this has been the burden of what I've been saying and of the longer piece, which is electronically available. Thanks very much.
Okay, so I'm going to be speaking for Jay Bernstein, kind of spectrally in a way. I'm very upset that he couldn't be here because he really made so many efforts to get here. He did everything that he could, and he submitted the paper a long time ago, and it's been available. So he had told me, it's a 3-part paper, and he told me that he was going to emphasize the second part, which is mostly about Hannah Arendt, but he was going to gesture towards the first part, and I think gesture toward the third part. I have no idea what the gesture would be, so I'm just going to have to wing it with gesturing. A lot of that I do in my response, so I'm not going to worry too much about that, and I'm mostly going to take from the second part. And just say that in the first part, Bernstein's claim is that Kant thought of himself as the first philosopher to secularize conscience by replacing the absolute authority of the voice of God with the absolute authority of universal reason. And Hannah Arendt felt that anytime it's a question of absolute authority, then you have a religious situation. So for her, Kant failed. And then Bernstein goes on to talk about Hannah Arendt and why she offered a more serious case. The third part involves a critique of Hannah Arendt. And I'm just going to be reading the last couple of pages of that third part in order for you to understand the title of the paper, which is The Necessity and Emptiness of Secular Conscience. And I don't think you're going to understand the necessity and emptiness unless I read the last 2 pages of the third section, towards which Jay was planning to gesture. So I hope that it's coherent. 2 in 1, Arendt's conscience. Because respectable society, friends and dear friends, people presumed to be possessed of rectitude and moral awareness, so easily succumb to the new order, and we're talking about Germany, Arendt infers that those who did not succumb should not be interpreted as differing from their fellows solely with respect to their degree of adherence to the moral rules. They were not better at applying moral norms, nor were those norms somehow planted in them deeper, nor were they in possession of a better set of norms and values than those held by their complicit compatriots. The old values, both enlightened and Christian, were worthy in themselves, and while it sometimes makes sense to distinguish between those for whom morality is only a matter of convenience, like Kant's grocer who is honest in his dealings because it is good for business, as opposed to those truly committed to moral ideas, that distinction alone would not be adequate to explain the sheer magnitude of the capitulation of German society to Nazi rule. Too many presumptively decent people succumbed. And the further notion of someone being more committed than others to the moral rules than others is fanciful. The difference between those who capitulated and those who did not is not quantitative, better, deeper, but qualitative. They judge differently, but without rules to guide them. Rules change. The question, Arendt urges, is what is it about those who resisted that allowed them or placed them in a different relation to reality? What difference can be pointed to that is other than hand-waving in the direction of better or deeper? Here is her blunt and initially unsatisfying response. Quote, "They asked themselves to what extent they would still be able to live in peace with themselves after having committed a certain deed. And they decided that it would be better to do nothing, not because the world would then be changed for the better, but simply because only on this condition could they go on living with themselves at all. Hence, they also chose to die when they were forced to participate. To put it crudely, they refused to murder, not so much because they still held fast to the command, 'Thou shalt not kill,' but because they were unwilling to live with a murderer themselves." Arendt's beautifully austere conception of secular conscience is a version of the familiar notion of personal integrity. I would not be able to live with myself if I did this socially required act. I would not be able to look myself in the mirror tomorrow morning. The result of this self-awareness is not that I ought not to do this, but the more direct and simpler, I cannot. The I cannot is the exemplary gesture of Arendt's conscientious act without obligation or ought or duty. Its austere power derives from its being nothing other than a particular modification of the power of self-consciousness that is a characteristic of human consciousness. Arendt contends that secular conscience is not an integral or structural feature of consciousness, a separate faculty, as it were, but solely a side effect of thinking. Beginning with Descartes, human consciousness was claimed to be distinguished from that of the beasts by being self-aware. Self-consciousness is a condition for consciousness, or to use Kant's severe phrasing, quote, "It must be possible for the I think to accompany all my representations, for otherwise something would be represented in me which could not be thought at all. And that is equivalent to saying that the representation would be impossible, or at least would be nothing to me." Unquote. Now, this phrasing can be misleading, since the one thing we're not directly aware of when we're engaged with things in the world is ourselves. It is for this reason that Kant begins his sentence with the modest, "It must be possible." Arendt's way of phrasing this thought is to say that when we are in the midst of engagements with the world, with knowing or doing or speaking or listening, we become emphatically one. I, as a single self, toss the omelet, solve the quadratic equation, survey the horizon, kiss your lips. The simple oneness of the self in its worldly encounters is not a good guide to its nature. We know that not only is the world composed of plurality or wildly diverse things, but that each individual thing is not only self-identical, but also different. It is what it is through not being something else. If in worldly encounters I am firmly singular, a simple one, in thinking I experience myself in my diversity, in my differences from myself. Thinking only occurs when I withdraw from the world, when in solitude I converse with myself. Arendt credits Socrates with the discovery of thinking, as well as its conscientious side effect. Thinking in its Socratic disposition has three distinguishing features. First, thinking is neither a specific talent, although some do it better than others, nor a privilege given only to an elite, like the leisure necessary for study. Thinking must be ascribed to everybody. It is the natural experience that occurs when we are possessed of solitude sufficient to ponder events in our life. Only misfortune or fear, finding in solitude only loneliness, prohibits ordinary humans from having the experience of thinking. Second, unlike the world-building activities of knowing, ordering and explaining empirical things and events, and resolving the demands that practical necessity requires, thinking does not terminate in positive results, in axioms proved, or valid moral rules, or a final code of conduct. Not only does thinking have an analytic bent, taking apart what was one and seeking out the meaning of its various parts, it equally finds its deepest satisfaction in the thinking performance itself, which can make thinking appear as skeptical or aporetic, as it indeed appears to Socrates' interlocutors. If concepts of honor or goodness or house are plural in their significances, then they can be understood as frozen thoughts. Thinking unfreezes concepts, returning them to their inherent difficulty, complexity, and incompleteness. Finally, because thinking is a withdrawal from the world, and the minute the world interrupts it, the self becomes one again, then it deals not with the things of the world itself, but their representations in thought. In this respect, thinking deals with invisibles, with things in their disappearance from the world. Because we normally move in a world of appearances, then thinking as a removal from the world is often unworldly, blind to the world, and the experience of thinking can be likened to that other utter removal of self from the world of appearance, death. These are unpromising materials from which to seek moral guidance. There is, however, one criterion intrinsic to the performance of thinking: consistency. But consistency here is not a matter of seeking consistency among propositions. That is, it is not a question of logical rigor, but something even more basic and primitive, from which arguably the law of contradiction itself derives, namely seeking agreement with myself. Arendt repeatedly quotes the passage from Plato in which Socrates states, quote, "It would be better for me that my lyre or a chorus I directed should be out of tune and loud with discord, and that multitudes of men should disagree with me, rather than I, being one, should be out of harmony with myself and contradict me," unquote. The first thing to note here is that my unity or harmony with myself is typically not even an issue when I am engaging with the world. Only if another presses me to square one thing I have said with another, or coordinate one action I have done with another, does the pressure to harmonize arise. And this is to say that in thinking, I am another to myself. I am, to follow Arendt's usage, two in one. The two in one of thinking is unlike the structural complexity of self-consciousness, aware of the world while implicitly aware of myself in that state of awareness. The two in one of thinking is the making explicit of the fact that I am I only through the difference between me and myself, a difference whose model is my relation to another. Thinking is thus best considered as the conversation of myself, with ambition of, if nothing else, gathering myself together, finding a unity or harmony among my views, for without some harmony they would not be mine, and hence they would be as if nothing to me. What makes my views mine rather than visitations from elsewhere is precisely that I have coordinated them, ordered them, brought them to sufficient unity in a manner that allows them to be said by me to belong to me. While at one level, then, harmony with myself is the requirement that my thoughts be integrated, at another level we might say that harmonizing represents the responsibility intrinsic to the experience of thinking. I might indeed contain multitudes, but if this is going to be more than a mental sack with multitudes deposited in it, then I must find a harmony among them. Their harmonizing is how they come to matter and mean. Or, as Richard Moran states this thought, I cannot treat mental occurrences as mere data from which I make inferences. Rather, quote, at some point, I must cease attempting to infer from some occurrence to my belief, and instead stake myself, and relate to my mental life not as something of symptomatic value, but as my current commitment to how things are out there, unquote. It is this very business of thinking, of the two-in-one finding or locating or creating the requisite oneness, that under conditions of moral extremity generates conscience as its side effect. Conscience, Arendt argues, is morality itself. Moral concerns not what must be done or what we must do, but solely what I must do. Morals emerge when political action is no longer possible, when there is no we who have the power to change things, and the ordinary rules and norms governing our lives together suddenly appear wildly insufficient. In moral experience, I am isolated and disempowered, and hence what I must do concerns strictly myself. Morality, Arendt states, concerns, this is a quote, concerns the individual in his singularity. the criterion of right and wrong, the answer to the question, what ought I to do, depends in the last analysis neither on habits and customs which I share with those around, nor on a command of either divine or human origin, but on what I decide with regard to myself." Unquote. Conscience is not the impulse to do good in the world, at least not directly. The primary mode of conscience is the negative, I cannot. Sometimes what I cannot do is do nothing. More commonly, conscience arises when I am required to do something that, in a quiet moment, I discover I cannot. The question that now arises, and that Arendt never compellingly answered, and may indeed not be answerable beyond her efforts, is what is the force of the demand for unity that might explain why I cannot? Arendt's dominant strategy is to suggest that what I am seeking when I seek harmony with myself is that I am capable of being friends with myself. If following Aristotle, we think of the friend as another self, then conversely, extending the analogy between thinking and conversation, we might consider the best image of our relation to ourselves in terms of friendship, of how I might be a good friend to myself. To be a thinking being is minimally to desire my own company, or at least not to be driven to run from it. And once the die is cast, to find my own company satisfying, someone easy to converse with, to whom I can confide with trust, as without fear or anxiety, someone who does not contradict me at every turn, who makes me better, who at least in part is my best self to me. Arendt's example of the failure of such a friendship with oneself is Shakespeare's Richard III. And here he's quoting from Richard III. "What do I fear? Myself? There's none else by. Richard loves Richard. That is, I am I. Is there a murderer here? No. Yes, I am. Then fly. What? From myself? Great reason why, lest I revenge. What? Myself upon myself? Alack, I love myself. Wherefore? For any good that I myself have done unto myself? Oh no, alas, I rather hate myself, for hateful deeds committed by myself. I am a villain, yet I lie, I am not. Fool, of thyself speak well. Fool, do not flatter. My conscience hath 1,000 several tongues, and every tongue brings in a several tale, and every tale condemns me for a villain." Richard's thinking is a manifold that one can find no harmony, no peace, no way of being at one with itself. His dialogue fractures first into outright contradictions, and then into 1,000 several tongues, a passage Arendt oddly never quotes. And it is that lack of peace, the fierceness of the self-awareness with its ultimate honesty and self-contempt, that makes Richard's voice so morally disturbing. At this terrified place, neither the urgencies of narcissism nor the ploys of self-deception are available to him. And it surely coheres perfectly with Arendt's doctrine that as the play progresses, and Richard's villainy with it, his soliloquies and addresses to the audience become fewer, as if he could no longer bear his own company. I think this is something Jay meant to say to himself. With her usual worldly coolness, Arendt reminds us that true villains rarely have regrets. That is why they are villains, and only those of good conscience can have a bad conscience. Richard III is intriguing because, while manifestly neither desiring nor even capable of living with a villain, nonetheless his villainy triumphed. He succeeded in proving himself a villain. And there is the difficulty. When necessary, thoughtfulness failed. Here is Arendt's account of the meaning of the necessity of being friends with oneself. Quote, "The partner who comes to life when you are alert and alone is the only one from whom you can never get away, except by ceasing to think. It is better to suffer wrong than to do wrong, because you can remain the friend of the sufferer. Who would want to be the friend of and have to live together with a murderer, not even another murderer?" Unquote. Let me simply grant that what Arendt here records corresponds to an authentic experience of secular conscience. I cannot, and I cannot because I could not live with the one who did this atrocious act. And because there is no escaping him being me, then I cannot. Even if there is nothing else conscience could be, this is insufficient. If you are Tony Soprano, say, then your soliloquy may tell you that unless you commit the vile deed, you will be unable to live with yourself. You will lack honor in your own and others' eyes. That being true to yourself involves doing this deed no matter how vile. For him, Tony Soprano, the issue is not whether he could live with a murderer, but whether he could live with a coward, a weakling, a failure, a man without self-respect. If conscience is finally a matter of being a friend with yourself, then everything will turn on your image of who you want as your friend. If you could not live with the person who let another unborn fetus be murdered, then you will conscientiously murder the abortion provider. Such has always been the errancy of conscience, the endless confessions of justified sinners. Arendt attempts to void or suppress this conclusion by insisting that since conscience arises in borderline instances, in moments of political or social crisis, where the normal work of ethics and politics have become unavailable, then we can only expect from conscience the negative I cannot, as exemplified by the Socratic dictum, quote, "It is better to be at odds with the whole world than being one to be at odds with myself." But this thought is easily available to the conscientious killer of abortionists. Hence, Arendt adds to the Socratic dictum the one she believes encapsulates the only true morality of conscientious thought. Quote, "It is better to suffer wrong than to do wrong. Because, to fill out Arendt's reading, I am capable of living with the one who has suffered, but I could not live with the one who has done wrong." Placing the I cannot with the better to suffer than do wrong principle, Arendt attempts to salvage thought and conscience by making them into the moral versions of negative capability. Conscience is the power of the moral no, the power to not act, not to be drawn into action when all the world is. The moral I cannot is the limit of the moral because the limit of thought, the limit of the friendliness of myself with myself. Anything beyond negative capability becomes the effort to do good, and doing good requires more than conscience's severe I cannot. Doing good in the world is world building, and world building cannot result from the ever incomplete activity and performance of thought. Even pressing the issue of why authentic thought is an ongoing performance that does not conclude in world building results will not salvage this analysis. And Arendt knows it. In Eichmann in Jerusalem, she reserves some of her harshest criticisms for those friends and dear friends, German inner emigres and the men of the Jewish councils, who, however splendid and well-meaning their intentions, either did nothing or worse, were culpable in their complicity. Not intentions, but actions matter, and hence the I cannot is worse than an empty intention if, when appropriate, it does not mean I cannot stand by and do nothing. Nor should one forget that if there is a hero, a man of conscience in Eichmann in Jerusalem, it is Anton Schmidt, the German sergeant who was executed in Poland for his activities in helping Jewish partisans by providing them with forged papers and military trucks. Arendt's encomium to Schmidt matters to the disposition of her theory of conscience. Quote, "And in those 2 minutes, which were like a sudden burst of light in the midst of impenetrable, unfathomable darkness, a single thought stood out, clearly, irrefutably, beyond question. How utterly different everything would be today in this courtroom, in Israel, in Germany, in all of Europe, and perhaps in all the countries of the world, if only more such stories could have been told." Unquote. I cannot is insufficient on its own because finally the question of whose company I wish to keep and the question of the content of conscience cannot be separated. Arendt's austere negative capability account of conscience will always prove inadequate on its own because by itself it has no response to the example of the justified sinner. Arendt knew this, since her encomium to Schmidt exemplifies her consistent view that we judge and tell right from wrong by having present in our mind some incident and some person, absent in time or space, that have become examples. Notice the absent in time and space. This indicates that these are representations and thus the stuff of thought. Hence, in choosing our company, we are choosing which stories we will tell ourselves, which heroes we will praise, which models we will follow. Paradigm cases, examples, and models, the stories that give moral shape to experience, replace rules and principles in Arendt's thinking. This is why Socrates' "it is better to suffer wrong than to do wrong" plays a dual role in her argument. It is meant formally to be the direct moral result intrinsic to the activity of thinking, but acknowledging that form is not enough. It is equally a moral content, the way one tells the story about Socrates' discovery of thinking and the true meaning of thinking. Arendt's account of conscience rises to its austere heights by a continuous and delicate shifting between employing Socrates' moral axiom as form and then as content. It is thought's negative capability in moral form, and it is the moral principle that arises from the authentic experience of thinking. Because choosing a moral content, a hero, a story, is just choosing with whom we shall keep company, then even the introduction of shining examples cannot save the idea of conscience from emptiness. There is a subjective moment to the choice of hero that is unsurpassable. While for the conscientious agent, the act of conscience appears as suffused with content, as just their moral subjectivity in action, what makes the act one of conscience is its first person, present tense, spatially local form. Here and now, I cannot do other than this. What is morally certain for the conscientious agent may well appear as morally repugnant to another. Its certainty does not entail its validity. And if we believe in conscience, then we must believe that each is entitled to her own conscience. On the face of it, would not the moral certainty of each cancel the moral certainty of every other one? And does not that inevitable result make conscience, no matter how thoughtful, not only empty, but dangerously so? And now I'm going to turn to just the last page and a half of Bernstein's paper, which I hope will explain his title about the necessity and emptiness of conscience. To claim of any individual that he or she is a moral being is to say that he or she is capable of conscientious action. Hence, we hold individuals responsible for their deeds generally, because we judge them capable of acting conscientiously. Even if we agree that individuals rarely act on their conscience, but rather act in accordance with standard social rules, we hold them responsible for their doings because they could judge and act otherwise. They could do what their conscience demands rather than what the social rules of the moment require. But this is to say that conscience is not only the fullest or most revelatory form of modern moral subjectivity, it is constitutive of it. As modern moral subjects, we are beings of conscience. And because the necessity of conscience reveals the unsurpassable moment of freedom in moral agency, the moment in which moral belief and duty's demand are taken up by the individual subject, making them emphatically hers, then it is the very necessity of conscience that entails its emptiness. Conscience is the subjectivity of the subject in morals. Conscience is the form that moral subjectivity takes for us moderns. While conscience as form cannot be relieved of its content emptiness, nothing in the nature of conscientious action itself will distinguish the heroic Schmidt from the killer of abortion providers. That does mean that conscience as form is not itself a kind of content. Once we recognize that conscience is the expression of the right of subjectivity, or the right of freedom in moral action, then it follows that we cannot be a modern free political community without also being a community of conscientious agents. This is why we take the conscientious acts of others so seriously. It is the minimum of respect we owe them as free moral agents. Even when we cannot abide the dictates of another's conscience, we nonetheless feel compelled to acknowledge their significance to the extent that, when conscientious acts do not transgress the harm principle, we extend to them a leeway, a respect, and even some legal courtesy that is otherwise not given to actions that are morally or legally wrong. But this is as much to say that we only recognize one another as joined in a morally charged political community to the extent we respect one another as beings of conscience. Perhaps we can now say that the true moral substance of conscience is its character as the constitutive form of moral action for modern subjects that is, in so being a form, at the same time morally empty. So that's Jay's paper. And now I'm wondering if you all have the stamina. I was the respondent, and I wrote a response to these two papers. It will take me about 15 minutes to read it. I don't know if you have the stamina to listen to it. Be honest with me.
Please, it would be a shame not to hear it, please.
Thank you, Michael. I noticed you're the only one to speak up. But you know what?
I want to hear it.
Kent wants to hear it. Well, you can imagine it was a challenge. And let me just clean off my glasses because I can't even see through them. It was a challenge to write this response. We have heard a philosophical account of secular conscience from Professor Bernstein, based largely on the writings of Hannah Arendt, but referring also, if you read the longer version, to Kant and Hegel. From Professor Greenawalt, we have heard a legal account of conscience, both secular and religious, whose focus is the historically difficult question of exemption from the law based on conscientious objection. In what follows, I'll try to provide as concise a summary as I can of both these complex papers, but my real aim is to put these papers in a dialogue. I concede that on the face of it, this will not be easy, but let me assure you that I'm a trained casuist, casuistry being a particular subfield of the evaluative study of conscience. So I'm a justified sinner. Professor Bernstein looks at conscience as a philosophical, even ontological issue. For Arendt, there is an absolute difference between the self-divided being who thinks in solitude and in so doing arrives at a moral judgment which will almost certainly be secular, and the undivided being who does not think, the being condemned explicitly by both Dostoevsky's Underground Man and by Woody Allen as stupid, but who can be, as in the case of Eichmann, the literally unthinking mastermind of genocide. In contrast to Professor Bernstein's philosophical emphasis, Professor Greenawalt considers conscience as a series of practical problems which arise when courts must adjudicate claims of religious and secular conscience. So let's start by looking at Professor Bernstein's argument more closely. And you've just heard it, so I'm sorry. The larger paper begins with a look at Arendt's critique of Kant's attempt, in the Critique of Pure Reason, to secularize conscience by shifting the ground of moral law from the authoritative inner voice of God to human reason. The universality of human reason allows Kant to grant it the status of a categorical imperative, one cannot not obey the moral law as established by universal reason. However, Arendt argues, Kant's insistence on unconditional obedience, not to the laws of God, true, but to the laws of universal reason, reveals his failure to describe secular conscience because the fundamental characteristic of secular morality must be that it requires not unconditional obedience, but rather a thoughtful consent to the law. Not surprisingly, Arendt's observation that German society's abandonment of its traditional moral values under National Socialism, followed by its unproblematic reclamation of those same values with the defeat of the Nazi regime, proved that traditional morality, based on assumptions about what it meant to be human, no longer possessed any power or influence over human behavior, and was henceforth to be considered null and void. Moral value and the capacity of human beings to act on the basis of conscience had to be reconceived if individual human beings were to acquire the capacity to judge and to act on the basis of that judgment, even in the face of unprecedented historical events, such as the complete collapse of a culture's moral convictions, underwritten by the model of unconditional obedience as the ultimate moral value. This ability is what Arendt calls thinking, which is done best in the absence of any transcendent authority, whether God or the state. Thinking also works best in solitude, when one removes oneself from the surround of conventional worldly appearances, and in so doing positions oneself to see everything anew, including one's own selfhood, and in a Socratic mode to question what one sees, including oneself and oneself seeing. In solitude, the self reveals itself to be not an integral, but an internally divided being, and what is also revealed is that this two-in-oneness of selfhood, the experience of one's otherness to oneself, is the prerequisite of thinking. As Arendt put it, I am I only through the difference between me and myself. Conscience is produced when, through thinking, one discovers not just the moral convictions that would allow one to live in harmony with oneself, but the means of owning those convictions, no matter what happens in the world, as a condition of one's being. So conceived, thinking, for Arendt, is inseparable from conscience. Thinking is conscience. Where Professor Bernstein parts ways with Arendt is in her orientation toward what he calls negative capability, an orientation that does not emphasize willing and then acting on one's understanding of the good, because there are as many notions of the good as there are individuals. Tony Soprano, Professor Bernstein points out, can live with himself as a murderer, but not as a coward or a dishonorable man, as he conceives it. There are those who think it is good to kill doctors who provide abortions. There are justices of the peace, employees of the government, who refuse to marry same-sex couples, to use two of Professor Greenawalt's examples. Given that secular conscience is not a universal phenomenon, recognized in the same way by everyone, given that it is fallible or partial, the product of individual thinking, Arendt leans toward a negative enactment of it. That is, one's responsibility to one's conscience is not to act on it, but to identify that which one cannot do if one is to live harmoniously with oneself. Despite what Professor Bernstein acknowledges is the errancy of conscience, he critiques Arendt's negative orientation, which she herself disowns in some of her work. Her preference here for the I cannot do X if I am to live with myself, because it excludes the possibility that one's I cannot may come in the form of I cannot stand by and do nothing, a good thing in the case of the ordinary German during the Holocaust, but a bad thing when thought by the murderer of the physician who performs abortions. There is nothing to be done about the inherent errancy of secular conscience, and the American Constitution disallows the privileging of religious conscience, which is itself errant, which may explain why the inalienable and natural right of conscience was elided from the First Amendment and replaced by the free exercise of religion clauses, as Michael McConnell and others have suggested. In what way, then, is secular conscience preferable to religious conscience, assuming that the latter were not as errant, as pluralistic as it is, and assuming that it continues to retain its vitality, which I think is undeniable? If secular conscience doesn't lead us into robotic obedience, whether of the religious or civic variety, can it be said to lead us anywhere most of us would like to go in order to live harmoniously both with ourselves and with our society? Professor Bernstein attempts to address this question with a little help from Hegel through his paradoxical and even counterintuitive claim that secular conscience is both necessary and necessarily empty. Why necessary? Because the freedom of the modern subject not to refrain from acting, but rather to act precisely on the basis of conscience, as it arises from Arendtian thinking, is a freedom constitutive of the modern subject, and which therefore cannot be alienated, cannot be given over to someone else, no matter what Dostoevsky's Grand Inquisitor says, cannot be suppressed. As Hegel asserts in The Philosophy of Right, a subject is the sum total of his or her actions. Professor Bernstein emphasizes that only internally motivated, subjective, rather than externally imposed, universal or objective actions testify to one's freedom. This is what makes conscience necessary, existentially rather than legalistically, even conceding that its very errancy makes it potentially dangerous. Why is conscience necessarily empty? As I understand it, conscience conceived as an empty form is prerequisite to the individual's freedom to arrive at moral convictions through the process of thinking. The stuff of thought, the content of conscience, the product of thinking, is not provided in advance in Arendt's view. Universal duty does not fill conscience as a given. This does not mean that universal duty has disappeared. It exists, but it exists as something to which one consents, through thinking and through conscience, whose emptiness permits the convictions that thinking produces to be converted into conscientious action. The emptiness of conscience means something entirely different in Professor Greenawalt's paper. Although I don't remember him referring to conscience as empty, correct me if I'm wrong, the concept is still there in the sense that the Constitution prohibits the privileging of the content of any individual conviction of conscience, although the conscience we might attribute to an organization is a different story, which I don't have time to go into, as Professor Greenawalt didn't emphasize for the same reason. This prohibition is what guarantees the separation of church and state. Requests for religious conscientious exemption have an advantage over their secular counterparts due to First Amendment protection of religious belief, another consideration I don't have time to go into. Still, the only way to provide nuance to that sense of emptiness is to examine the various claims of conscience that have commanded the attention of the justice system in the form of requests for exemption from the law on the basis of conscience. And the focus of Professor Greenawalt's paper is on the way requests for exemptions are evaluated. An attendant problem, which I will not discuss here, is the objection that the very idea of exemptions is discriminatory, which Professor Greenawalt mentioned, and it's very similar to the historical objection to the idea of religious toleration as discriminatory. Let me note that Professor Greenawalt's paper begins where Professor Bernstein's ends, at least the longer online version of his paper, which I read to you. In the sense that the question at the heart of both papers is how a pluralistic and secular society manages situations in which claims of conscience, religious and secular, may be absolutely antithetical, and whether they may be accommodated by society as a whole in Professor Bernstein's paper and by the law in Professor Greenawalt's without inflicting harm, a touchstone for both. This allows me to propose that Professor Bernstein's philosophical understanding of conscience as an empty form, whose very emptiness is necessary for the creation of subjective moral content, is not incompatible with the way jurists are constrained to understand conscience as an empty form if they are to create a coherent and fair, because objective body of law regarding exemptions to the law based on an individual's conscientious objection. The philosopher has the luxury of resting with his insight that conscience is empty, but the jurist does not. The emptiness of conscience and the urgency of requests for exemptions constrain the jurist to assign, fairly and objectively, various weights to the various claims with which they're presented. But as Professor Greenawalt shows, this process of weighing and measuring is an extremely difficult process, raising questions productive of other questions, most of which are fundamentally speculative. The answers to the questions Professor Greenawalt has posed here involve measurements based, case by case, not entirely on objectivity. I'm not denying that the jurist is aided by the existence of legal precedent, but to a significant extent on subjective calculations that then become legal precedent. How do we know what counts as a claim of conscience? We try to assess the intensity of moral conviction, whether religious or secular. Does it seem trivial or strong? We try to assess the legitimacy of a moral conviction. To what degree does the request for an exemption have to do with morality as a value as opposed to some practical desire? We assess other intangibles, like the sincerity of an individual's conscientious belief. As in Professor Bernstein's remarks, the question of authentic personal identity also weighs in. To what degree is a conscientious conviction tied to an individual's sense of who she fundamentally is as a thinking being, in the Arendtian sense, such that if she did what the law required her to do, she could not live with herself? And how is that unprovability of identity to be factored into the legal judgment? What is its relative weightiness in the case at hand? A philosophical question. How do we measure the degree of an individual's involvement in a moral problem? Is his position in a morally fraught situation proximate or peripheral? And who, with confidence, can measure such subjective rather than empirical spaces? And then there's the problem of weighing the claims of institutional to individual conscience, of religious to secular claims of conscience. The jurist tries to determine the comparative weightiness of religious and secular conscience. What is at stake in these hypothetical measurements made for the sake of determining the legitimacy of exemption? Exemptions are in their very nature discriminatory, and yet they're necessary if we are to strike a balance, another metaphor of scale, in a stormy sea of competing moral interests, as if we were burdened with the task of writing the Federalist Papers of conscience. Were conscience not an empty form, as Professor Bernstein proposes, Professor Greenawalt would not be presenting us today with the legal calculations and measurements necessary to give it sufficient weightiness to qualify it for exemption. Last paragraph. I'll end by reinvoking the question of how, while respecting the claims of conscience, we refrain from inflicting harm. Professor Bernstein suggests that in the final analysis, we deal with incompatible claims of conscience by respecting one another as conscientious people, even when we find each other's convictions of conscience abhorrent. As a liberal society, we tolerate them unless they inflict harm. But as Professor Greenawalt's paper demonstrates, especially in the second half, which was online, but which he didn't focus on here today, the assessment of what constitutes harm and the degree to which it is inflicted is not necessarily self-evident. For this reason, a third party, the justice system, which no one thinks is infallible, is nevertheless permitted to determine who suffers and who inflicts harm in cases of conscience, and to what degree, and then to apply penalties and protections accordingly. The challenge here is to arrive at more specific and nuanced judgments, while at the same time retaining the flexibility to accommodate social change and shifting mores. And so we end with another paradox. In the law, the greatest degree of specificity in the work of judging, in the work of judging claims for exemptions, is enabled by greater degree of generality in legal discourse. The best way to honor individual conscience is to amplify its generalizable characteristics. Thank you. So questions to Professor Greenawalt may now be asked.
Or questions to Nancy. I mean,
I don't know if I'm capable.
So I have a question for Professor Bernstein.
Ah.
And I guess also to Nancy at the same time.
Yes.
You know, part of the account of Hannah Arendt, which by the way, actually, always, I think he's left, but Nathan also had an account of Arendt in his paper, the longer version of it, that actually uses almost identical quotations that
Yes.
Bernstein used. So the question is, this dialogue with the self presumably takes place in language. That is, it involves language. It's not just an exchange of sensations, presumably. You wouldn't call it a dialogue.
Our conversation.
Or a conversation. And therefore, how can it possibly be understood except as an internalized dialogue with others? And if
Yes.
that's the case, how can it not be a social event which therefore opens itself up? And in fact, I would even go further and say that if the agent who engages in this internal dialogue imagines that her dialogue is, in principle, immune to any external feedback or evaluation or assessment or conversation, then she'd have no way of distinguishing it from madness.
Yes.
Right?
It would be
So-
kind of schizophrenic in a way.
Well, it would be sort of schizophrenic. So
Yeah.
the question, I think, is why at all adopt this kind of individualistic and subjectivist framework if you're starting with dialogue, which would seem to me to open up the possibility of engaging others, and therefore would refute the claim that was quoted a couple times, there are as many notions of the good as there are individuals. You might say there's many notions of the good as there are communities.
Yes.
And therefore there's potentially as few notions of the good as might be derived from dialogue among communities.
Yes.
Could indeed converge. So why rule out convergence, and therefore how do you get emptiness? So I'm not getting the whole, I'm just not getting the philosophical structure of this thing.
Okay, well, I'm very sorry to have to bear the burden of defending this. So let me just say where I agree with you. I understand what Arendt is saying, but I do think that across her works she contradicts herself, because she also emphasizes action. In fact, I think she emphasizes action, taking action, as much as she does this idea of thinking in solitude. And she emphasizes action in the public sphere. She describes action as something that you must take, even knowing that you can't control the trajectory of an act. Nevertheless, you have to take action. So she is self-contradictory in that respect. So then we have this idea of the two-in-oneness of a certain type of thinking that's done in solitude. And as you say, and I think say rightly, it can only happen in language. How else could it happen? Even if she were dreaming, if thinking were somehow dreaming, there would still be language there. And so I think it's an interesting thing for those of you who are not literary scholars and nevertheless know the work of Mikhail Bakhtin. The whole premise of language is that it's inhabited, it comes to you pre-inhabited by the voices of other human beings, that you can't express anything, even a word, without it's already being freighted with other people's understandings of that word. So you're bringing, even if conversation is somehow imagined as internalized, if it exists in language, a community, in Bakhtin's sense of the word, already exists. What I also find interesting is the degree to which Professor Bernstein relied on literary examples. So, and I'm not even referring to, the Shakespeare example was meant to explain kind of the idea of being self-divided, which for her is a prerequisite of thinking, of conscience. But I'm referring to the idea, and this is where I see, and if he were here I would ask him, the idea of conscience being an empty form through which conscience, rather moral content can kind of, as if conscience were a kind of empty conduit, and moral content went through this. It reminds me of Walt Whitman saying, I'm not a poet, I am a conduit for the voices of others, and these voices all come through me. And there seems to be a similarity. But she does talk about content, and she does say that content pre-exists in the sense that she says what we deal with are representations. Inevitably, in language, we're dealing with representations. We think when we think about our moral options, we think in terms of stories, narratives, of heroes, of models. These are all literary terms. So that's another aspect of Professor Bernstein's analysis of Arendt and thinking and the emptiness of conscience, its formal existence preceding its content that I don't understand.
Okay.
Michael Perry?
Kent, during your talk, you asked me whether I agreed or disagreed with something, and I've lost the question. Do you want to ask it again?
I thought your discussion this morning would indicate that, but I mean, you might want to qualify that in some ways, that the line should never be drawn between religion and non-religion. And one of the things I asserted was that for, let's say, the exemptions that are going to be given for organizations in relation to same-sex marriage, that it is, or the health insurance, that it is appropriate to limit them to religious organizations. Now, I didn't really get into that, but I think there's a difference between religious organizations and non-religious organizations. And I think the message the government would send if it said any organization that, where the leaders, as a matter of conscience, thought this, would be sort of troubling for the overall idea that same-sex marriage is okay or that these insurance things are supposed to be provided. And so the question was whether you do think there are at least some examples where it is okay to draw the line between religion and non-religion claims of conscience, or whether you think across the board you should never draw such a line.
Well, with respect to that example, if you think about Robert George and his colleagues' defense of excluding same-sex couples from civil marriage, they are emphatic that that is not a religious argument, and for understandable reasons. And in fact, more broadly, the United States Conference of Catholic Bishops' position that inherently non-procreative, as they call it, inherently non-procreative sexual conduct is immoral, which is not a position specifically about homosexual conduct, but about lots of sexual conduct, is not a religious argument. So just with respect to your specific example, it would be strange, I think at least, to be saying that a religious organization can be the beneficiary of this exemption when its rationale is not a religious rationale, but some other organization with the very same rationale cannot be the beneficiary of the exemption.
Okay, well, of course, this ties in a little bit with what I said very briefly about natural law this morning, and the idea that there are natural, and I go into this in the paper a little bit, the natural law position on contraceptives, which is advanced by Catholic natural law philosophers such as George and the guy is at Oxford and Notre Dame.
John Finnis.
Yeah, Finnis. I think that's very unpersuasive on its merits. And so this is something that's put forward, and I think they do honestly believe that this can be justified in non-religious terms, but I think that really it's the religious bases that are, what is really moving them, even though they may not recognize this. But there's also a step from what you said to the next thing, and that is, let's assume that their reasons are exactly the same as you just said and not subject to this qualification I just gave. It's another question whether, if any of them thought that given any help to this would violate their conscience, whether they would also think that that would be non-religious. Now, the people you're talking about, they think you can justify this on non-religious grounds, but they also think it happens to be true that on religious grounds it's clear that God has condemned us. So these are not people who just have this secular argument without any religious connection. And I think that I'd suspect that when we get to whether they think they couldn't participate, that the religious thing would come in. But anyway, that's a hard question with these natural law people who...
Well, let me just say, it's not just the natural law people, it is the magisterium of the church.
I understand.
And so your skepticism is not a skepticism about secular natural law thinkers who are trying to provide a non-religious rationale for the position of the church. It's a skepticism about whether the magisterium of the church is truly speaking, offering a non-religious argument. And I just want to emphasize something you know, and I'm sure most people here know. It's important to distinguish the Protestant and Catholic thinking about these issues. The Catholic thinking about these issues is not biblically based. It is not, so it's no part of the Catholic argument concerning sex outside of marriage or contraception or same-sex sexual conduct that somehow there's a biblical warrant for its position. That is not the Catholic position. It's hard to assimilate that in a society in which most religious arguments about same-sex marriage, of course, are biblically based.
Well, I come back to the point, yes, the magisterium may believe, and I think it's right, that this is a standard. I think this is a Thomist belief, which is still very strong in the Catholic Church, that these arguments that can be put forward on non-religious grounds are good arguments. And I agree that there's much less emphasis on the Bible than you would get in a lot of Protestant denominations. However, They also believe that the tradition of the church has established, and because the magisterium takes these positions, this is something that Catholics should believe in and follow. So this is not just, this is a rational ground, and we should persuade you on the basis of this rational ground.
Well, that's a separate issue.
Well, I don't think it's a separate issue.
It's a separate issue about what you're now talking about is the church's understanding of its teaching authority, which is a different issue from what the church believes and the integrity and persuasiveness of what it believes about inherently non-procreative sexual conduct.
But I still come back to why do they think they have to have an exemption? I think it's substantially because the teaching of the church has been over time, and the magisterium has said that this is forbidden. And as you well know, and I do mention this in the paper, there actually was a point before the Second Vatican Council, or maybe right after it, where there was a group set up of Catholic thinkers, authoritative Catholic thinkers, the majority of which thought the church should change its position on contraceptives.
John Noonan, among others.
Yeah, and that, of course, got rejected by the Pope and so on. But these are complicated issues, no doubt about it.
Adi?
You mentioned something about Obama healthcare. You're not entirely sure. I'm not asking your opinion whether he can do that. He can sort of the government can force constitutionally insurance to be universal, if you will.
I'm assuming yes to that.
Your hesitation is really raised a question in my mind. I mean, the way you phrased it. So what do you do when the law, this is the framework from which to solve this problem is the law, which, as you said, we don't think is infallible, and the moral issue, if I can say that, is this problem of having millions of people who are in suffering because of an economy of suffering, if you will, within the system. So what if that problem cannot, I mean, how do you see it as someone involved in law? How do you solve that problem when your framework to solve the moral question may actually be the rate limiting step?
I didn't.
The law may not, let's say the law actually fails the Obama health care.
You mean it gets struck down?
Right.
All right, well, let's just be clear about what we're talking about here. There are a number of cases. The main arguments of the cases are that these open-ended statutes, which I mentioned, like RFRA, are understood in a certain way, should provide the exemption in and of itself. And I don't think anybody really thinks, well, there might be some extreme libertarians who think, but in terms of what's legally likely to happen, I don't think anybody thinks that just the requiring of insurance, apart from any religious claim or claim of conscience, would itself be unconstitutional. I don't think anybody, almost nobody, would think that's actually sort of, going too far for the government in a way that would be unconstitutional. And I think there the only question is, whether that's statutorily an excessive exercise of authority. I don't agree with that position either, but that at least is a plausible position. But as far as the Constitution is concerned, it really is more, there could be an argument the Constitution requires the religious exemption, but that would require undoing a case which I dislike as much as some of the others have spoken about. That's Employment Division versus Smith, but as long as that's on the book, it's really the statutes that mainly have to be used. And I might say about that, because this is when you talk about jurists and so on, that when some of these things can be legislative choices to do it one way or do it another, and then it's the legislatures that are deciding. Or you could have these open-ended statutes, and then there's a weighing that's going on, and then that's done by the courts. So it depends on how you set it up as to whether you're going to have a lot done by the courts with an open-ended standard, or you try to make specific legislative choices, or do a combination of those things.
So any other questions before we wrap up? All right. Thank you so much to Professor Greenawalt and Jay Bernstein and Nancy.